Welcome to the Timesing Free Formal RICS CPD tutorial video. This topic is relevant to the surveying profession and construction industry and has a formally structured program that includes learning outcomes that will enhance your current knowledge and develop your technical skills. I'm Pascal Walsh. I'm a fellow of the RICS and I have a Master of Laws specialising in construction law and arbitration. I've spent over 30 years supporting and advising clients across multiple sectors in the construction industry globally. Towards the end of the video, you will find details of how to complete a short test on the tutorial topic, and upon successful completion of the test, you will receive a copy of your results to evidence achievement of your formal CPD. Timesing is regulated by the RICS. Learning objectives and outcome. The objective of this tutorial is to build upon the student's existing knowledge through learning and improving their skills and information. The outcome of this tutorial is to teach the student what UK statutory adjudication is, when does it apply, how the process and procedure works, what happens when a decision is made, what are common construction disputes, where it applies globally, and how to prepare for an adjudication. Each student should then consider how they are going to apply what they have learned and plan what further learning might be required. Section 1. The history of adjudication. The late 1980s and early 1990s was a time of significant litigation for the UK construction industry. Major projects faced lengthy and costly disputes in court. The government of the day recognised that the industry required change and commissioned a report into reducing the problems of the construction industry. The report was led by Sir Michael Latham, and Constructing the Team was published in 1994. It has since become more widely known as the Latham Report. Latham recommended that adjudication should be the normal method of dispute resolution, and that a system of adjudication should be introduced within all standard forms, and that this should be underpinned by legislation. The recommendation aims were to improve cash flow, to prevent unnecessary business insolvency, and to create a quick and less expensive dispute resolution mechanism as an alternative to a slow and expensive litigation. There is a legal maxim that justice delayed is justice denied. Many attribute this saying to William Gladstone, who was a former UK Prime Minister in 1868. However, the actual concept can be traced back in law as far as the Magna Carta of 1215, which reads, "To no one will we refuse or delay the right of justice." The construction industry had frankly become fed up with having to wait for too long for decisions of justice to be made. Statutory adjudication became law in England and Wales in 1996 under Part 2 of the Housing Grants, Construction and Regeneration Act, more widely known as the Construction Act. This Act was later amended by the Local Democracy, Economic Development and Construction Act in 2009. Scotland and Northern Ireland each have slightly nuanced legislation, regulations and features, but with broadly the same overarching goal. Section 2. What is adjudication? Adjudication is a form of interim dispute resolution that involves an independent person deciding a dispute. It is conducted privately, unlike court proceedings, and the outcome is not a matter of public record. Whilst it follows a procedural process, that process is less onerous than what would be required to be followed by the parties in litigation. It follows a limited timetable, typically 28 days from start to finish, unless extended. The adjudicator's decision is temporarily binding and must be complied with until the dispute is finally determined by litigation or arbitration, should a party decide to go to formal proceedings. This is commonly referred to as the pay now, argue later principle. Section 3. When does statutory adjudication apply? Statutory adjudication applies to any construction contract as defined in the Construction Act. The Act can be studied at www.legislation.gov.uk. A construction contract is defined under Section 104. In summary, a construction contract means an agreement for the carrying out of construction operations, whether this is by an individual, a subcontractor, or through labourers, and includes architecture, design, surveying, and advice on decoration and landscaping. This means that adjudication applies not only to building contracts, but also to professional appointments. Construction operations are defined under Section 105. The definition is extensive and importantly describes those operations that are not defined as construction operations. These include drilling for gas, extraction of minerals, assembly, installation or demolition of plant, machinery or steelwork for the purposes of supporting or providing access to plant and machinery on a site where the primary activity is nuclear power generation or treatment plants. Processing of chemicals, pharmaceuticals, oil, gas, steel, food and drink. Manufacture or delivery to site of components, equipment, materials, plant, machinery or systems, in other words, supply-only contracts. And also artistic works, such as sculptures. This means that most building and construction contracts are covered by the Act, with the exception of Private Finance Initiative (PFI) contracts, oil and gas contracts, and contracts dealing with the extraction of minerals. PFI contracts fall outside the scope of the Construction Act because they include such a broad scope of services and responsibilities, including financing, operation, maintenance, and the provision of long-term performance services. Where a residential occupier is carrying out work to a house that they either occupy or intend to occupy, then adjudication does not apply, as defined under Section 106. Originally, Section 107 provided that the right to refer a dispute to adjudication only arose where the construction contract was in writing. This section was later repealed to include both written and oral contracts. The right to refer disputes to adjudication is defined under Section 108. Any party to a construction contract has the right to refer a dispute to adjudication at any time. A party to a construction contract cannot contract out of the Construction Act. However, a party could, if they were, for example, preparing an oil and gas contract, decide that they wanted the Construction Act to apply and could contract into the Construction Act to have statutory adjudication apply to their contract. There is no limitation to the type of dispute that can be referred to adjudication. Any type of difference can be referred. It could be over payment, delays, the interpretation of a clause, the definition of a specification, or any other matter in dispute between the parties. Section 4. The dispute. The parties to the dispute are the claimant and the respondent. The claimant is the party who initiates the adjudication and is seeking payment or clarification of contract terms. The respondent is the party responding to the claim and either defending the claim or presenting a counterclaim. The parties to a construction contract are entitled to refer a dispute arising under the contract to adjudication at any time. However, the dispute must first have crystallized. Dispute crystallization occurs when a disagreement or conflict between two parties becomes clearly defined and tangible. The parties have articulated their positions and specified the demands and nature of the issue at stake. If the dispute has not crystallized before the notice of adjudication is served, the adjudicator will lack jurisdiction to determine the dispute and could be challenged on enforcement. Section 5. The Notice of Adjudication. The adjudication commences when the party who wishes to have a dispute decided by an adjudicator serves a notice of adjudication on the other party to the construction contract. The notice typically includes details of the claimant and the respondent, a summary of the issue that needs to be adjudicated, and a formal request that the adjudicator address and resolve the issue. The notice of adjudication must relate to a crystallized dispute between the parties, and the notification must contain enough detail to set out the nature of the dispute sufficiently. The notice is a formal document and an essential part of the adjudication process, setting the wheels in motion. Section 6. The appointment of the adjudicator. The adjudicator is a neutral third party who decides the dispute impartially based on the facts and law. The appointment of the adjudicator takes place within 7 days of the notice of adjudication being served. An adjudicator is not required to have any formal qualification to adjudicate on a dispute. Adjudicators can be from a variety of construction-related backgrounds, including but not limited to lawyers, architects, engineers, and surveyors. The adjudicator may be a person that has been agreed between the parties in advance, or the parties may agree to the person being nominated by a professional adjudicator nominating body. Here is a list of 10 nominating bodies. The Chartered Institute of Arbitrators, the Construction Industry Council, the Institution of Civil Engineers, the London Court of International Arbitration, the Royal Incorporation of Architects in Scotland, the Royal Institute of British Architects, the Royal Institution of Chartered Surveyors, the Technology and Construction Bar Association, the Technology and Construction Solicitors Association, and the UK Adjudicators. If there is no agreement on the person to be nominated or the body that can nominate the person, then the party wishing to commence the adjudication can simply approach any nominating body who will then appoint a person as adjudicator. Appointment as an adjudicator carries great responsibility. The subject matter of the dispute should fall within their sphere of professional competence. They must be able to undertake the task within the set time limits. They must ensure there are no conflicts of interest and that they comply with the notice of adjudication. The powers of the adjudicator arise out of the express and implied terms of the contract between the parties. Section 7. Jurisdiction. Jurisdiction is the authority granted to the adjudicator to decide the dispute. Jurisdiction is one of the few grounds where the courts may decline to enforce an adjudicator's decision. The adjudicator may completely lack jurisdiction, or the adjudicator's decision may have strayed beyond the jurisdiction the adjudicator has. There are two components to jurisdiction: threshold jurisdiction and internal jurisdiction. Threshold jurisdiction arises when the essential elements are in place that give the adjudicator the authority for their appointment. This will include the contract, the entities of the parties, the contractual adjudication provisions, entitlement to commence, crystallized dispute, number of disputes, previous adjudication decisions, and the referral timeline. Internal jurisdiction arises when the scope of the adjudicator's jurisdiction is governed by the dispute identified in the notice of adjudication. The dispute in the referral must not fall outside the scope of the dispute in the notice of adjudication, because the adjudicator will not have jurisdiction to decide on them. Section 8. The Adjudication Procedure. Adjudication is a quasi-judicial process. The adjudication procedure is reasonably flexible, and it is up to the adjudicator to direct the parties on how to proceed. The rules which apply to the adjudication may already be agreed between the parties. If there is no agreement between the parties, or the rules do not follow the Construction Act, then a backstop set of statutory rules kick in, which is known as the Scheme for Construction Contracts. These regulations came into force in 1998 and have since been amended in 2011. When the scheme applies, Part 1 provides the framework with which the adjudication is to be conducted, and Part 2 includes various payment provisions, which replaces any provision in the contract that does not comply with the Construction Act. The adjudicator will invite written submissions and evidence from each party. Typically, a referral of dispute document is submitted by the claimant, which outlines the dispute and includes supporting evidence and legal arguments. A response document is submitted by the respondent, which outlines their position and includes supporting evidence and legal arguments. If the adjudicator deems it appropriate, the adjudicator can direct that hearings are conducted where further evidence, witness statements, cross-examination, or adjudicator's questions can be outlined. The adjudicator may also require a site visit to understand the dispute in greater detail. Whilst the process is straightforward because it lacks the complexity of court procedures, the adjudicator only has limited time and scope for review, meaning in-depth hearings or evidence may not be fully explored unless they are necessary. The adjudicator is expected to act judicially in exercising their powers. This means they are expected to give each party a fair opportunity to put forward their case and respond to the other party's case. Section 9. The adjudicator's decision. The adjudication procedure is complete when the adjudicator issues a decision. The decision is usually in writing and contains the reasons for the adjudicator's decision. The adjudicator's decision is required within 28 days of the date of the referral. The 28-day period can be extended by a further 14 days if the party who commenced the referral consents to an extension. The parties can also mutually agree to extend the period to such longer periods as they both agree is required. The Construction Act gives the adjudicator immunity for their actions, provided they have not acted in bad faith. That means the adjudicator is not liable for anything done or omitted in the discharge of their functions as adjudicator, unless the act or omission is in bad faith. The adjudicator is permitted to correct his decision so as to remove a clerical or typographical error arising by accident or omission. The adjudicator will comply as fully as possible with the rules of natural justice, particularly when determining the adjudication procedure, dealing with the parties and their submissions, and finally in reaching the decision. Section 10. Enforcement of the adjudicator's decision. The adjudicator's decision is binding on the parties until the dispute is finally determined in court or arbitration. This means that the parties are required to comply with the adjudicator's decision. If a party refuses to comply with the adjudicator's decision, then the other party can enforce the adjudicator's decision through the Technology and Construction Court, or TCC, which is the part of the High Court that deals with construction-related litigation. The courts have devised relatively quick proceedings for this, in keeping with the intent of adjudication, and when enforced, the adjudicator's decision takes effect as a judgment by the court. The courts will generally enforce the adjudicator's decision, and only where there is a breach of natural justice, that is, where the adjudicator has conducted the adjudication unfairly, or where the adjudicator lacked jurisdiction, that is, where the adjudicator did not have the legal authority to make a decision, will the court consider that the adjudicator's decision should not be upheld. The reality is that few disputes come before the courts or arbitrators for final resolution. This is because in the vast majority of cases, the parties accept the decision of the adjudicator. Section 11. The cost of adjudication. Each party, whether they win or lose, will usually pay for its own costs of administering the adjudication. This may include their own staff's time, legal and contract advice, or quantum time and technical experts. The adjudicator has the power to allocate the adjudicator's own fees and expenses between the parties. The adjudicator may usually include, as part of the decision, that one or other of the parties are to pay the adjudicator's fees and disbursements, or that the adjudicator's fees and disbursements are to be paid as a percentage from each party. But normally the most obvious solution is that the losing party is directed to pay the adjudicator's fees and disbursements. Whilst the cost of adjudication is less expensive than litigation or arbitration, because there are fewer formalities and legal costs, the process may still incur substantial costs if the dispute is complicated or if enforcement is required. Section 12. Common construction disputes. The number of different types of construction disputes brought to adjudication each year may rank differently. However, there are some common reoccurring categories that tend to feature regularly. Payment. Technical disputes over payment notices. These are commonly referred to as smash and grabs, as they are often seen as hasty, aggressive, or opportunistic, resulting in a quick resolution or short-term gain, typically at the expense of a deeper, more thoughtful analysis of the issue. The term is borrowed from the concept of a smash and grab robbery, where thieves would smash a window and grab whatever they could find from a store. Final accounts. Disputes over the true value of a final account. Loss and expense. Loss is the reduction in income or profit because the contractor cannot complete the work within the expected time frame. Expense are the additional costs incurred due to the delay, such as extra labour, extended equipment hire, or other overheads that increase as a result of the delay. Prolongation. A prolongation claim includes the costs incurred due to the delay itself, which could include the costs for extended labour, machinery, material storage, and overheads during the extended period. Damages, including liquidated and unliquidated damages. Disruption. A claim for compensation for inefficiencies, interference, or changes in the way the work was carried out, leading to additional costs or delays. Disruption does not necessarily mean that the work is delayed in terms of completion, but rather that the work was carried out less efficiently than planned, leading to higher costs. Interim accounts. Disputes over the true value of an interim payment. Variations. Changes to the scope of the contract. Extensions of time. Requests made by a contractor to extend the completion date of a project due to certain circumstances beyond their control, which have caused delays in the project's progress, or assessments by the client of the revised completion date, taking into consideration the contractor's own delays and concurrency. Termination. The parties may terminate the contract for various reasons, including breach, frustration, convenience, insolvency, and rescission. Termination clauses can be complex and include very specific procedures to follow to ensure the termination is valid. Defects. Disputes referring to flaws in design, materials, workmanship, and overall system failures. Professional liability. Disputes over the level of the duty of care owed, whether breach of that duty occurred, that the party suffered damages or loss, and that such damages or loss were as a direct result of this negligence. Breach. Where one party fails to fulfill their contractual agreements and the other party suffers a financial loss as a result of this non-performance, substandard performance, or delay in performance. Measured works. Disputes over the quantities and items in the bills of quantities versus the actual quantities and items completed on site. Contract formation and interpretation. Disputes over mutual intent, legal capacity, clear offer and acceptance, mistake, and ambiguous terms. Global claims. Claims that are global do not demonstrate the cause and effect of the events creating the claim. Quantum meruit. Claims over recovery of the reasonable actual value of the services provided. Suspension. Disputes over the right to suspend work and that proper procedure has been followed. Warranties. Disputes over the warranty contracts that protect certain rights for third parties. Condition precedents. These are events that must occur before a party is required to fulfill a contractual obligation or before a contract becomes legally binding. Time bars. Time limitations within which certain rights or claims must be exercised or enforced. If the claim is not brought forward within the specific time frame, then it is typically barred or forfeited. Section 13. Global influence. The success of statutory adjudication in the UK has influenced several countries to implement laws with similar aims. England, Wales and Scotland introduced their respective legislation in 1996. Northern Ireland and Australia's New South Wales followed in the late 90s. New Zealand, the Isle of Man, Singapore and Australia's remaining states introduced their legislation in the early to mid-noughties. Over the last decade or so, Malaysia, the Republic of Ireland, Canada and Hong Kong have all introduced adjudication into law. Each country and even regions within countries have slightly different procedures, but all include the basic principles of a system enshrined in law: availability to parties to a construction contract, legally binding until overturned by the courts, and conducted within a relatively short time frame. Notably, the Irish adjudication procedure only allows for payment disputes to be brought to adjudication, whereas in Hong Kong, the regime only applies to public contracts. Along with those countries listed here, Zambia and South Africa are two countries that have held advanced discussions in recent times about the introduction of adjudication legislation. Section 14. Preparing for an adjudication. In preparation for adjudication, whether launching or defending, it is important to keep good project records. Max Abrahamson was an Irishman who in 1965 wrote, "A party to a dispute, particularly if there is arbitration, will learn 3 lessons, often too late: the importance of records, the importance of records, and the importance of records." His book, Engineering Law and ICE Contracts, became known as the Engineer's Bible, and this quote is more often used in the form of the mantra, "records, records, records." Over 60 years later, his words are still relevant today. Each party should present their case to the adjudicator clearly, logically, and with as much contemporaneous recorded evidence as required to outline the facts. This allows the adjudicator to decide based upon the best possible information available. Where a contract prescribes the procedure required for bringing an adjudication, those contract procedures must be followed step by step properly, and in the absence of the contract prescribing the procedure, the appropriate legislation must be followed. If you find that you need to launch an adjudication, or that you have to respond to a notice of adjudication, always seek professional advice from those that are experienced and qualified to deal with the process. Section 15. Conclusion. Whilst a negotiated settlement between parties is still the most popular alternative dispute resolution method, in the past 5 years, an average of 2,000 adjudications per year have been decided in the UK, with the majority of those being decided within 42 days from the date of referral, and only a few dozen each year going through to the court for enforcement. In 2020, the Supreme Court endorsed adjudication as a conspicuously successful addition to the range of dispute resolution mechanisms available for use in what used to be an over-adversarial, litigious environment. On the one hand, adjudication has provided a quicker, cheaper way of resolving disputes in private. On the other hand, given the tight timetable applicable to adjudication, and the fact that the adjudicator is not usually bound by precedent in the same way the court is, means the quality of the decision can be of concern. That being said, almost 30 years after the introduction of adjudication, on balance, the legislation remains an essential tool for maintaining cash flow and has had a positive impact on the construction industry. We hope that you have found our tutorial informative today. We recommend some further reading. If you wish to record this tutorial topic as formal CPD, please follow the link in the description, where you will be taken to a multiple choice test, and upon successful completion of the test, you will be issued your results as a record of hours completed. If you'd like to be part of the Timesing tribe, please subscribe to our channel. You will get updates on when new videos are posted, and it helps our channel's popularity, allowing us to make more content. If you enjoyed our tutorial or found the content helpful, give us a like. This helps our visibility. And comment below if you'd like to let us know what other topics we should do. We do appreciate your engagement. Please share our tutorials with your colleagues or fellow students. You can also follow Timesing on LinkedIn or check out our website for more updates. Thanks for watching.